Change the future of settlement of disputes. I want to say thanks to all the speakers who have accepted to be with us today. A big thanks to Radwa Elsaman, Senior Legal Advisor, Tetra Tech, Professor of Law, CAIR University Law, Egypt. She helped us so much in the organization. Substantially, she organized everything. She involved all the speakers, but for a last-minute problem, she is not with us, unfortunately, today. So she say hello to Radva. Thank you for your commitment, and we hope to see you soon in our next event. Now, before to go ahead, I will leave to the moderator, Alessio Foderi. Sorry, I forgot to say that I'm Aldo Scaringella, the founder of the LC Publishing Group. And I will leave to Alessio Foderi, journalist in Inhousecommunity and Legal Community, to moderate this roundtable. Thank you very much. Stay with us.
Hello, everybody, and good afternoon to everybody, and thank you for being with us in these few minutes where the attendees are joining our webinar. Let me thank our speakers, and I'm gonna introduce them. Connected with us today, there is Ghada Qaisi Audi, Deputy Executive Director and Managing Attorney, CAIR San Francisco Bay Area and Independent Arbitrator USA. Welcome with us. Then we have Stefano Azzali, General Director, Milan Chamber of Arbitration, Italy. Ahmed Shehata, Senior Program Coordinator for the Middle East and North Africa, IDLO, Italy. William Kosar, Legislative Reforms Consultant, UNDP, and Public Financial Management and Legal Specialist, ADB. And then finally, Bashar Malkawi, Global Professor of Practice Law, James E. Rogers College of Law, and University of Arizona, USA. I see you all connected now with us. Thank you for being here. And thank you, Aldo, also for the introduction. As he said, Radwa is not with us. Let's start immediately, I would say, as I already introduced in our program. At the very end of the webinar, there will be a Q&A session. So for our virtual audience, please feel free to ask questions to our speakers. If you are addressing the question to a specific speaker, name it in your questions. Otherwise, just write the question in our chat. And at the very end, we will leave 15 minutes to collect the questions and let our speakers give the answers. I also remind the speaker to be in time, in 5-minute time in your intervention, so that we can collect the question, of course, and answer at the very end. Thank you again to everybody. Of course, the topic of today is clear to everybody, the impact of the pandemic and COVID-19 in the field of arbitration. Today, we will try to go deeper and analyze it from different perspectives. Let's start with Ghada from US, and I would ask to Ada, welcome. With COVID-19, as in your view, arbitration finally caught up with the technological tools that allow dispute resolution to be more efficient, and I'm thinking, for instance, to video conference, electronic case management, and digital case bundles?
Sure, thank you, first of all, Alessio, and also to Aldo and the entire team at LC Publishing Group for bringing us all together. A big thank you to my fellow panelists as well. I look forward to exchanging a lot of very international viewpoints today with everyone around the table, our virtual table. Yes, you know, as COVID-19 has had such a tremendous impact on and long-lasting effects on all facets of our society and our day-to-day, our economy, the way that we work and the way that we conduct business. It has also fundamentally changed the way we resolve disputes. I guess I would start by kind of drawing a parallel to, you know, the workplace. There were so many naysayers who said that we couldn't remotely work, and were very much in a lot of regions and across the US as well, were sort of the idea that you had to conduct your work in the office setting. Well, of course, that has been proven entirely to be false, because we've been conducting work remotely now for all these months as we've entered into the COVID-19 scenario. So, and in that respect, I think there's been a lot of positives, if we can say that we found any kind of silver linings, is that it really firmly placed this idea that remote working does work. And in the same way, everyone is really forecasting, well, what will it look like when we do get to return back to our offices? I have a feeling that it's going to look like a combination of what we have been doing now, and there will be a lot more flexibility because we've seen that it works. So really looking now at the dispute resolution institutions. So courts and dispute resolution institutions across the globe have really had to take another look at how we can continue to move cases along without having then a severe backlog. And as we can see that so many courts and arbitral institutions, tribunals, mediation centers have successfully been able to adopt remote hearings and the like. And in fact, what I think is very remarkable is that these technologies and the ability to do this has actually been with us for a very long time. I go back to my time at the Dubai International Financial Center Court, where I was a deputy registrar and had worked very closely with implementing online case management. We, you know, were offering already back in 2010 and 2011 virtual hearings, and we had rules that were dealing with e-discovery. And these were happening all over in different jurisdictions. And so these tools are not really new, but what I think has happened is that there's been an acceleration of the adoption of these practices. And I think that's a very good thing. Will they be here to stay once we do resume back to a more or a new normal? It appears that it will. Because really one of the hallmarks for alternative dispute resolution was that it would be cost effective and that it would be efficient. And virtual hearings have really added a new element in terms of efficiency and cost savings. And I think that's very important. And it is something that we will probably see a hybrid continue. And in fact, Baker and McKenzie had recently completed a study, in their study of 250 private practice and in-house lawyers, judges, and barristers in the UK, 65% wanted hearings that were less than 1 day to continue to be virtual. So I think that we're going to continue to see some hybrids. And I think it's been, again, the silver lining here is that we've seen accelerated adoption of some of those technologies that were already existing and are now really been fully adopted.
You raised some interesting topics such as technology efficiency, but also this hybrid scenario. We will tackle these topics forward during our webinars. I would move now to Stefano Azzali, General Director of Milan Chamber of Arbitration. And I would like to ask to Stefano how actually arbitration and arbitral institution answered the emergency situation related to COVID-19 pandemic in Italy, and so the experience of the Milan Chamber of Arbitration.
Thank you very much, Alessio, and welcome to everybody, and thanks for having organized this event. Rather than in Italy, I would try to give you in a few minutes a picture of the overall situation, not only in Italy, because I believe it might be more interesting. Of course, I cannot talk for all the institutions around the globe because I do not represent them and I don't know all of them. And then also because it does depend on the local restrictions. They were countries that they've been hit before others. Italy was probably one of the second one after China to have been hit by the pandemic. So others that they came later. So it really, and then the dimension of the restrictions were different. So of course I cannot give you one picture that does fit for all the situation, but I will give you some, at least about the major institutions. And I think that the major institutions, as Ghada said, they reacted immediately. And literally, they reacted from Friday to Monday. It was over the weekend that something, at least in my country, happened. So they really, really were very reactive in doing what? And I'm thinking of the major institutions like the ICC, like Stockholm, like the ICDR, like Singapore, like Milan, or like Vienna, all the major institutions. First of all, they adapted their services to the restrictions. And that was also very material reaction, as Ghada said, like tools to be used, technical tools. Then something additional, they issue notes, guidelines, information, suggestion, advices to users, to counsel, to parties, to arbitrators. And that it was very, very useful because, as I will say in a minute, they were lost. Many of them, they were lost. Thirdly, they joined. And I can tell you, I witnessed with my eyes, in March 2020, I had so many meetings, Zoom meetings like this one, with my colleagues from all over the world, doing the same job I'm doing, running centers. We really merge and we really exchange ideas, solutions. We were a network. I felt being in a real network of cooperation. Last but not least, for sure, actually, even probably the best, we were really assisting parties and all the players of an arbitration case in running the machine. As I said, they were lost, and I think they really needed some guide, some direction, because at the very beginning, they didn't know what to do. They didn't know how to move, how to react. Arbitrators on one side, parties on the other side, the witnesses, and everybody. So I think that and sometimes the reaction was towards guerrilla tactics, filibustering tactics by someone that could not believe that it was a wonderful, chance to postpone everything, not to play anymore. So I really think that in that circumstances, the role of the arbitral institution was evident, was clear, that can be crucial. And I think that never as before, arbitral institutions, they were seen as key players. And that's something that I think was very, very positive for the machine moving on. Then 1 minute more, because I had 5 minutes and I'm still, I'm not running late so far. And I tell you what the Milano centers did. And I just give you figures, and then we might comment later on. From March 1st to December 31st, that is 10 months of pandemic, we organized 220 hearings, arbitration hearings, 220. 194 of them were virtual. 194 out of 220. Only 14 were semi-virtual. Someone was in place, others were virtually in remote mode. And only 12 were in person. 12 in 10 months and 194 in remote mode in 10 months. Then as for mediation, we organized 1,291 hearings. 1,291. And 90% of them, they were virtual. And only 10%, that is equal 1 for 1, so 141, were in person. Then we had 120 new cases, arbitration cases filed, and then we had 926 mediation cases, new mediation cases. This shows you that the machine never stopped. We had to slow down a little, I think, in March and April, the first 2 months. Then I must say, thank God we slowed down in August, because that is a holiday season in Italy. So there was some, rest for everybody, also for users. But the other, months we were running fast. And that's, I think, the answer of how was the reaction of arbitral institutions during the pandemic. Sorry, I was 1 minute late. I do apologize. This is from me from now.
No worries. Thank you, Stefano, also for sharing these figures that we can, of course, comment later on. I would move now to Ahmed, and maybe to have a perspective also for the MENA region. So what has been the impact of COVID-19 on access to justice? And actually, what are the main obstacles the pandemic created with particular focus on the court performance during the crisis, all related to the MENA region, as I was saying? Thank you.
Thank you so much, Alessio, and thanks for LC Publishing Group for inviting me to this very interesting webinar, and also for the presentations of my colleagues. Just let me start by saying that in the MENA region, many of the countries there introduced a lot of measures to prevent the spread of COVID-19, but those measures included lockdowns, restrictions on social media, and restrictions, on social gatherings, and closure of public facilities. And also they had an impact indeed on the criminal justice and the access to justice in general, where courthouses remained closed in many countries or suspended their operations. Of course, as a result of this closure and reduced operations, proceedings were already delayed, case management was already delayed. And in most of these MENA countries, what has been considered only urgent cases, they were dealt with, but the other cases were already left behind, which kept the courts, of course, backlogged by many cases in the jurisdiction, and people weren't able to access justice. And indeed, many people in the pre-trial were left in the detention centers, and their detention, of course, indeed prolonged. Of course, that made a great violation for the fundamental human rights from one side, but also contributed a lot to prisons and detention centers overcrowded. So if we take a number of laws, relevant laws where the case is being dealt with in the courts, we'll see, for example, in the civil law, that many situations, citizens and businesses need to take procedural actions. For example, a cross-border case, where a case is initiated in one country and has an impact in another country, but they were unable to process the case in the court due to the measures that been introduced, and the spread of COVID-19, of course, made this impossible. Also, in the number of some insolvency cases, the COVID-19 pandemic and the shutdown of large parts of the economy across the countries, of course, led to a drastic drop in the cash flow of companies and become, of course, a threat to mass insolvencies. Also, if we go to another issue related to victims of domestic violence, for example, the situation of domestic violence has been became in many countries, for example, like in Tunisia, like in Egypt, like in other countries in the North Africa, became fivefold than before, because the isolation during these periods of confinement and lockdown, people stay with their abusive partners, children stay with their abusive parents, and they have this kind of like coercive control from one side, negligence from another side, violence from different hand, and their access to support services, their access to legal rights is quite limited, and they cannot get access to all of this. Of course, also, if we talk about other issues related to cybercrime, of course, I mean, COVID-19 had, during this period of lockdown, people, of course, rely more on working from home, teleworking, or smart working, as it's called in some countries. I mean, cyber attacks became more and more, present. Access to justice against these cyber attacks became so hard, and cyber criminals, they had more opportunities to make some attacks against these vulnerable populations, of course. Also, if we talk about the situations in prisons, the prisons became under very much of pressure in order to limit the impact of the virus, and people in the prisons, even they aren't able to see their families, but they aren't able also to do their normal activities, and they have regular visits. And that, of course, made a challenge for the prisoners from one side, but also for the prison staff from another side, and it became a catastrophe situation, let's say. So also that created a lot in how this people in the prisons, their cases being delayed, their management of cases being already prolonged as before. Of course, we understand that during the pandemic, lockdown, of course, might be necessary to protect the health and safety of the justice professional from one side, but also from the court users from another side. But we say that it should be done in a careful and proportionate way or manner, because this limitation, the access to justice, it's quite, from one side, it's limiting people from accessing their fundamental rights, but the other side is also fundamental principle for rule of law, and the public services of justice must be maintained, let's say, as much as possible during this crisis, by providing access to justice through different measures or different means. For example, in some countries, we see that there is online services being provided by the courts, and to strengthen access to information, for example, through the court website or other means of communication, like people can have like a hotline which they can call for the court to gain more information, or by email. Unfortunately, in our Middle East and North Africa region, most of the country lack this access to technology or availability of an electronic services that provide information to people or provide referral system to people where they can go and access justice or access lawyers, access legal support or legal aid system. I will stop here for the time limit that I have, but I'm happy to answer any questions that participants might have to me.
Thank you so much, Ahmed. Yes, of course, I take the occasion also to remind the audience to send questions through the Zoom chat, and we will answer them at the end of our roundtable. I would move now to William to actually continue this topic we are raising in different regions. So I would like to ask, what are your experience as an arbitrator in 2020, so last year with the pandemic that exploded?
Thank you very much, and good evening, everyone from Kenya. I see at least one Kenyan and one Ugandan among the participants. So good evening. I think it's trite to say that COVID proved that we do not need to be anywhere. My main occupation is working in international development, and I found that my practice has actually increased over the past year with assignments in Chuk, Myanmar, Fiji, Solomon Islands, South Sudan, the Sudan, Papua New Guinea, and a whole bunch of other little places that you've probably never heard of, and I certainly never heard of. And in fact, I should have probably been sitting in Auckland, New Zealand right now, watching the America's Cup instead and dealing with these aforementioned Pacific Island countries. But even before COVID, I tried to do my arbitrations remotely anyway, as I've been traveling 90% of the time previously. I live in a coastal village in Kenya, north of Mombasa, and I see there's a lot of Italians on tonight. So you will all, of course, know Malindi, and I actually live in a village called Watamu. So and that's where I am right now. But even before, I tried to encourage remote hearings. Before Zoom exploded and before I even knew what Zoom was, I'd be using WhatsApp. Because it's time consuming and expensive for me to travel to the hearings in Nairobi. So again, I think again, it's trite to say you're a social misfit when your life has hardly changed, before or after a pandemic. But I think Ghada had said earlier about the amount of workforce, that are things going to change after the pandemic? And the statistics I got is that in 2019, 3 to 5% of the population or workforce worked from home full time, while 60% had a job that could be handled remotely. Now, between 80 to 90% of people want to work from home, at least part time. So it's estimated, I think, that we're going to see at least 20% of people work remotely, and I think it is proven that we do not need to be traveling anywhere. Technology exists. I'm grown weary of the number of Zoom conversations and meetings and things that I've done, and I'm sure many on this panel and among the attendees are also weary of Zoom. But I think it's still here to stay. And again, it's just so easy that, again, with our co-panelist Stefano in Milan Chamber of Commerce, I don't need to leave my home here in Kenya to now do a hearing in Milano. Likewise, Ghada mentioned Dubai or whatever. I think this is one of the great things, and I don't really think that anything is going to change post-COVID. There may be a small uptick in travel, but I think it's a year or more away. Anyway, I would certainly invite any questions or comments in the methodology discussed, and thank you for paying attention.
Thank you so much, William. You also raised the topic of the change and in the scenario of the remote hearings, but also how the landscape will be post-COVID, a topic we will tackle also at the end or when the other of the participants and the speakers would like to comment it. To finish this first round of our virtual roundtable, I would go now to Bashar. Thank you for being with us. In your case, I'd like to ask you if you can please focus on the dispute system used by the WTO and evolution of complaints involving health and environmental protection exception claims during the pandemic.
Thanks, Alessio, for a nice introduction, and thanks also for LC Publishing for this opportunity and for meeting everyone, at least virtually this time. If you look over the years, you'll see that the WTO dispute settlement mechanism proved to be one of the successful among international organizations. We have a strong dispute settlement body. We have a strong appellate body that proved very successful in settling disputes, international trade disputes disputes among countries. Thus far, there was about 582 cases resolved by WTO panels and appellate body panels. And now, if we move on to the area, of course, over the years, those panelists looked over environmental issues and looked over health issues. And it's frankly a mixed bag. Some countries were successful in using environmental measures in a way to restrict trade. Nevertheless, those panelists found that these trade restrictive measures do not run afoul of WTO rules. If we talk about the French asbestos case, where Canada brought an action against the French government for imposing restrictions on the importation of asbestos products. So that was successful one, but for other types of cases, unfortunately, the panelists found that these measures were not the least trade restrictive, that there could be other alternatives not to restrict trade. If we talk about, for example, the shrimp turtle cases, if we talk about the renewable energy cases between the US and India. Now, so it's a mixed bag. Now, if we move on to the COVID-19 era, we see that countries over the past few months adopted several measures, intervened in the market, flushed the market with cash, with stimulus packages, with subsidies. Now, if we move to the trade side, you'll see that governments adopted trade restrictive measures in terms of a higher tariff on some medical supplies, in terms of imposing export restrictions or essential medical supplies or hand sanitizers or soap, etc. Or even for investment measures, we've seen that countries adopted restrictive measures or restrictive screening measures, such as in the case of the EU. And even in the case of Japan, we've seen that countries are moving away from China and they are looking for other supply chains, trying to diversify any external economic shocks. My concern, as William highlighted to some extent in his speech or presentation, would be the post-COVID-19 era, whether those type of measures adopted by countries worldwide nowadays might be acceptable under the defense of necessity, but would they be implemented as well after the post-COVID-19 era or recovery, and would a WTO panel sustain any defense in names of protection of human health or environment or public safety? So this would be the question to be answered. Can these types of measures sustain any attack by other countries as measures used to disguise perhaps discriminatory treatment in terms of trade or restrictive measures? Thank you.
Thank you so much, Bashar. Of course, the things you mentioned are, of course, linked to the future and so to the post-COVID scenario. If any other of the speakers wants to give a comment, feel free to ask me and I can give you the floor to reply. Otherwise, we can carry on with a second round of our roundtable with Ghada. And actually, I would like now to focus on how have the companies changed the way they pursue dispute resolution since the pandemic last year, and what types of analysis should companies undertake before commencing a dispute?
Thank you. Well, you know, the challenge for companies right now in the COVID situation is that you know, the demand for goods and services has dropped in some segments, or probably the majority of sectors, but you're not able to really reduce all of your fixed costs. And so I think we see a lot of liquidity crunch and capital crunch that is hitting a number of businesses. So I think what we're going to see are a lot of companies that are really doing a very deep analysis into their options. So I think maybe some companies that would have had a more readily ready-to-go strategy of litigate or arbitrate, mediate, are probably taking a little bit more of a slower pace in terms of making that decision because of the costs involved. So as we've been, speaking about here today, where you can reduce the cost around the procedure of the arbitration, that probably gives businesses a little bit more leeway to then be able to pursue the dispute. But I think right now a lot are in the wait and see phase and are doing a lot more diligence to do that cost benefit analysis to really make sure that, are the assets going to be there? Is the counterparty that they are actually trying to resolve or collect against still solvent? And I think, time is going to tell. But I think, there are other alternatives as well, or other options that are available for companies. I think a lot of companies will probably be looking at third-party funders for more of a cash injection to be able to pursue those disputes. And again, with the shift now to utilizing more cost-efficient ways to resolve the dispute. So if the virtual hearings continue, as William mentioned, the cost of travel, that's an added cost to the process. So all the ways that the process can continue to be efficient will help businesses to be able to make that choice. But I would definitely like to hear a little bit more from Stefano on, whether he's seen kind of he gave us the statistics, so it seemed like those were steady, but whether he thinks that those will go up, or if he thinks that parties are kind of waiting and seeing a little bit more.
Thank you, Raja. I will give the floor to Stefano to reply actually to what has just been said.
Well, I don't know. I would need a crystal ball that unfortunately I don't have. Otherwise, I would not be here, but I would be in Malindi enjoying the sun with William and other friends. I don't know. I think my feeling is that last year business dropped down for sure in many sectors that they are the ones, much to my regret, more usually solved in arbitration. I'm thinking of construction, financial contracts, and so I think less contract means less arbitration clauses, and so we will see a drop, I think. Not now, not in 2021, probably not in 2022, but starting from 2023, probably we will see some reduction of cases, I think. Most of the time we have our statistics, and they are not very different from other institutions. From the time you include an arbitration clause in the contract to the time you start an arbitration, the average duration length is 3 years, 3.5 years. That's the average. So I think that we will start having problem in 2023, more or less. Then, of course, the crisis lead to more disputes. So probably there will be less contract, less arbitration clauses will be counterbalanced. I cannot say hopefully, because that sounds not nice, but they might be counterbalanced by more arbitration. So I don't know. It's quite, I think, difficult to predict. To answer to Alessio question, what will be out the future arbitration 2.0, let's say the next one, can take advantage of the 2020 experience. I must say, preliminary, I must say that I act also as an arbitrator, and I still think that in-person proceedings most of the time, not for all the phases, but for few steps are better in person than in remote mode. I'm thinking especially about the cross-examination of either fact witnesses or expert witnesses. If I am in the room and I am an arbitrator, I feel better. I don't know. Maybe body language or expressions, details. I don't know. And then what I miss of remote hearings is the exchange of ideas that you have with your colleagues arbitrators during lunch, during a coffee break. So I still think that at equal, let's say, condition, in person is still a very the best solution. But if I look of also the disadvantages in terms of cost, in terms of time, in terms of speed, then remote will be the future, also after the pandemic. That's my impression. Then another probably outcome that arbitration proved to be very flexible. As I say all the time to my colleagues at the chamber, if we made it with COVID, we will make any need of the parties, we will be ready to answer, to satisfy any situation we will face in the future, because we made it in 2020. So I think that flexibility has proved to be very, very high. Then I think that there will be an increase of the use of arbitral institution, because as I said before in my previous intervention, they prove to be really, really key. They can be key players. Not all of them, because some of them probably they did not react properly. I don't know, I cannot talk for all of them, but for sure the ones that they reacted and they supported players in the arbitration field, they proved to be crucial. And I think that they will be more understood their role and more used in the future. Then I think that event like this one, that's a third outcome that will stay, probably will give us more opportunities to promote arbitration all around the world. So I think that will be a very, very promotional impact. And then cooperation among institutions will be will stay. It's here to stay for sure. We will not, go back. And I think that at the end of the day, I think that arbitration, the 2.0 arbitration, will be better than arbitration 1.0. Will be more sexy, I think, for users, because it will be more efficient, less expensive, faster. And I think so at the end of the day, I think that the new animal that we will have will be nicer than the old one.
Thank you so much, Stefano, for sharing your thoughts on this, and still remain on the role of technology that the majority of you actually take into account when talking about COVID-19, because of course we are remote even now for this webinar. I would like to go to Ahmed again, talk about e-justice as an opportunity actually to respond to public health emergency. So how, Ahmed, to maximize the use of technology in facilitating access while leaving no one behind and enabling the respect for procedural rights?
Thanks again, Alessio, and everyone. Well, let me start by saying that information technologies offer the opportunity for the justice sector to continue function during public health crisis or during any crisis in general. But let's also make sure that IT solutions such as online services, remote hearings, video conferences, and also this futuristic, of developments of digital justice solutions must always be designed in a manner that respect fundamental rights of people and principles of the fair trial in general. and also, I mean, their use should be accessible to people from one side, but it has a clear legal basis from the other side when we develop them. But indeed, I mean, going back to the point that really information technology is really a key to respond to these issues that I already explained on how access to justice is delayed during the lockdown, and where courts are delayed their proceedings, and in some cases are shut down completely. Let me here bring a good example, which it came to my mind recently in the UK, where the High Court, a trial at the High Court, which was conducted from a virtual courtroom, actually completely during the lockdown in 2020, using a video conferencing services that was also streamed on YouTube from one side. This virtual trial was conducted in light of emergency of the coronavirus legislation that was passed in the UK, which called Coronavirus Act 2020, if I'm not mistaken. And it has, of course, a temporary nature, that act, but it paved a lot of good way to the digitalization of courtrooms. And also a similar approach that was also adopted in the English Commercial Court as well during COVID-19, where the UK Supreme Court already had its own channel since 2013, but they made the hearings publicly streamed, and making video conference facilities more available now, where all the the court users or the case parties are able to attend virtually the case and receive a judgment in the case in timely manner, which has already from one side speeded up the procedure, but from the other side guaranteed access to justice even during the COVID-19 crisis. But going by the example of the UK courts, for example, I mean, there are a number of various of issues need to be taken into account to realize or establish an e-justice court program in general, because when we talk about these good examples, seem to be like quite easy for us to be implemented or to be done, but they need to be made properly, and courts have to ensure budgets, and governments have to support this establishment of the e-justice system. For example, that they need to set up video conference infrastructure to secure the quality of the proceeding from one side, not using a slow internet, of course, securing the participation of the required attendees in the case management. Of course, arrange public broadcast by, of course, aligning with the public media. Whenever possible, of course, and depends on the type and the nature of cases. Of course, there is a number of other issues. For example, if it's a broad country case, that we need to ensure, of course, interpretation, proper swearing of the witnesses, etc., etc. That's not enough for now, of course, because once these courts are established and to operate, I mean, in a digital manner, we need to make sure also the judges are lawyers, paralegals are all well capacitated to perform this digital and proceed the cases through these digital mechanisms. I would give like some examples from good practices that we have seen in a number of cases where digitalization became necessary, and countries are moving towards this digitalization in the Middle East, where the monitoring of the case flow, the quality and the performance became something very essential. So the well-functioning case management systems and mechanisms of these courts have to be quite present from one side during the public health crisis. Court presidents, judges, and any authority responsible for the court management should continue, of course, to monitor and manage the cases according to their responsibilities. They have to give a particular attention to vulnerable population where their cases need to be dealt with in a time manner. For example, the violence, domestic violence cases, and of course the cases related to commercial acts. Training is something fundamental in this area, where training for effective management of cases during a health crisis became something essential. Judicial training should adapt to the emerging needs, of course, and the use of IT, because in some cases and in a number of countries, using information technology is difficult, not only for the court users, but also for judiciary or for the lawyers, and that should come hand in hand with establishing any e-justice system. E-justice system in a number of countries, proved to be a good response to COVID-19 and public health emergency and other emergencies as well, and also proved that cost will be less from one side, efficiency from the other side. Everyone can access to justice from the other hand as well, and transforming the judiciary, for the future, should be also approaches in a positive manner, and also should be done in a respect for fundamental rights as well, which also guarantee, the rights for people in need to access justice as well. I'm not sure if I have exceeded my time limit, but I'm happy to also and remain available to answer any questions. Thank you.
Thank you so much, Ahmed. I think it's really interesting, actually, that you share different perspectives from different countries as well, as it was saying before. And I would move now to William. He said before he's connected, he has joined us from Kenya. So documents-only arbitration are not permitted under the rules of the Kenya branch and the Chartered Institute of Arbitrators. If you could tell actually more on that point.
Well, thank you so much. And they've defined a remote dispute resolution to include, but not limited to, video and audio conferences, email and offline means, such as documents-only proceedings. If I may also, Article 3 defines virtual hearing rooms, or says that are the preferred way to conduct hearings remotely. And I'll refer the question to Stefano, whether you have such things over in the Milano Chamber of Commerce, the virtual hearing room, or it's being set up. Now, they also pointed out that they're also recommending under Article 7 that in the context of both current and future proceedings, it is important that the parties affirmatively agree to the use of a particular type of remote proceeding. Now, the Kenya branch goes on in their revised rules to talk about documents-only arbitration. Which does not require sort of physical attendance. But it also talks about, hybrid proceedings, where, and again, I think Stefano can give us some guidance on that, where, the meeting or hearing allows for simultaneous physical attendance and virtual participation. So, in my case, the example would be, well, people are together in Nairobi in a hearing room at the Arbitral Center there. And I'm here sitting on the beach in Malindi, carrying on the hearing by Zoom or whatever. So I think, again, technology is opening up a lot of possibilities. Documents only, I don't know if that is the way to go. I believe Stefano was saying earlier as well that he likes the body language. Now, yeah, I don't know if I want to be in the room, or a small room with a bunch of people. But again, with Zoom and the other parties that are together, I would prefer that. So at least I can talk, I can hear the tone of their voice, and try to cajole the parties into a settlement where possible, rather than just relying upon lengthy briefs and written argument. So that's my say on this. I think, like I said, we're going to be seeing, we're going to see more documents only. And again, I'll defer to Stefano whether they're allowing documents only in Milan. But I think we're going to see a lot of hybrid proceedings, and if not just full-on remote proceedings as we step forward. Because as I've said before, and Stefano said, hey, I mean, I could now do an arbitration in Milano or Taiwan or wherever without actually having to get on a plane, which is expensive for our clients, because for me, the clock starts running the minute I step out my front door. And again, I'm just recollecting, I did a training in Rwanda for the Ministry of Justice, Minijust, about 8 years or so ago, to the litigation department on arbitration. And I remember thinking, this student was really, this lawyer was really insulted. Clause, they had to draft an arbitration clause. He chose the Taiwan Chamber of Commerce, and I said, how silly. Well, maybe that's possible now, because no one has to get on a plane to go to Taipei. No one has to get on a plane to go to Milano or Geneva or the CAIR Arbitration Center. So I think Stefano was raising his hand and looking to say something. So let me get off the line.
Try to put your microphone closer, otherwise we can only hear some background noise. Try to speak again, and sorry to interrupt.
Yeah, sorry, yes. I'm in a windy location. I live in a typical Swahili style house with no windows, and the warm beach breezes are blowing through. So sorry, ladies and gentlemen, but you can at least hear the breeze, if not feel the warm East African breezes from the Indian Ocean.
So William, if you want to finish, otherwise we can carry on. Just tell me.
No, that's all I have to say about that. And I'm interested in hearing again what the other panelists have to say about the CIArb rules on remote hearings, and see how it would work in their jurisdictions if they're not following that. Thank you very much. Good evening.
Sure, thank you. If any other of the speaker wants to reply to William. Nobody at the moment. So we can go on with Bashar. You just raised the environment as a topic related also to COVID-19. So the pandemic, as well as the projection for climate change related disaster, highlights the need for structural and juridical reform of the WTO dispute system. So what's your feelings on that point?
Thank you. Before even the COVID-19 crisis started back last year, we've seen that the WTO was in a crisis mode. You have an impasse at the appellate body, where some countries such as the US mainly, who block the renewal of appointment terms for the WTO panelists or the appellate body panelists. So although it was successful over the years, but the accusation was that the appellate body stepped over its mandate, and that the issue of a precedent that should not be forced upon other countries in future cases. Now, the rules are there for justification of any measures taken as a result of COVID-19. We have mainly Article 20, the general exception article, which provides the opportunity or the leeway for any WTO member to adopt a measure that it considers necessary for the protection of environment or protection of human or animal or plant life or health, or for the preservation of natural resources, you see a bunch of exceptions there or subparagraphs there where the WTO provides a leeway for members to adopt these types of measures. So one could argue that these type of measures adopted in times of COVID-19 era could be afforded the protection of Article 20. Of course, over the years, the WTO developed jurisprudence over these matters. For example, these exceptions or these measures that adopted to restrict trade under the name of environment or protection of human life should not be a disguised restriction on trade. Countries who adopt these types of measures should look for other alternatives. Should be the least trade restrictive measure. The purpose should not to defeat the ultimate purpose of liberalizing trade and accessing markets. So you have a rich WTO jurisprudence with regard to these environmental cases or health cases. If we're talking about the asbestos case, renewable energy case, if we're talking about the shrimp or turtle cases. But the question that arises, whether there is a potential for future WTO complaints on the basis of COVID-19 measures. And the potential is high. Countries, perhaps not now, but perhaps next year or the year after next year, some WTO members may challenge measures taken by other countries as they consider these types of measures restrictions on trade. So the question would be whether these type of measures can sustain the defense of Article 20. What I propose for the moment, and everybody is busy saving lives, and perhaps there should be a type of WTO waiver on the litigation before panelists, at least for the short term and the mid-term, until countries pass and cross over this crisis peacefully. So the one proposal would be to impose sort of a waiver on the type on complaints filed by WTO members against others based on these types of measures. Other alternative, and I've seen this in the previous cases that settled by the WTO, that WTO panelists do not have expertise in these areas. So perhaps we should create sort of bifurcated panel system where you have panelists who will decide all other cases with regard to goods, trading services, intellectual property, anti-dumping, safeguard measures, subsidies. And you have on the other side, other types of panelists who have specialty in COVID-19 measures and health issue, in human rights, in climate change expertise, who might decide these type of cases. So I would argue that for the short and mid-term, the two steps that should be taken in parallel. One, there should be a moratorium on filing claims by WTO members against others, claiming that these types of restrictions on the export, for example, of medical devices constitute trade restrictions, and as such, they violate the spirit and the rule of the WTO. In parallel, there should be a preparation for having a pool of expertise or experts in those areas who might have the expertise in settling these disputes, which will come one way or the other, but it's a matter of time. Thank you.
Thank you so much, Bashar, and thank you to all of you for all the interesting topics you raised. I remind our audience, don't be shy. Feel free to ask any questions. To wrap up a little bit, I think it's really interesting what have been said concerning arbitration and how it has changed during 2020, the role of flexibility, the reactivity as well of the arbitration, and also as future scenario, an hybrid scenario actually. And it was really interesting to listen to all of you as you are from different jurisdictions as well. I will start with a question actually. Someone among you already raised this topic. One area that is sure to change as a result of COVID-19 pandemic is litigation. So I don't know if one among you want to give some ideas or feelings on that, looking towards 2021 as well. Raja?
Sure, I can kick that off. Well, I think a lot of what we've been talking about today will really be an opportunity for the justice systems to really take this opportunity to make necessary changes. I definitely saw a lot of that kind of movement in the Emirates, where whether it was the Dubai municipal courts or at the Dubai International Financial Center courts, where you could fully register your case online. The Dubai courts will send you text messages to remind parties of the next steps. That you can submit all of your case management bundles through electronically. And I think it does provide a tremendous amount of access to justice, especially to the points that Ahmed was raising, that when you close the courts, you end up with a huge backlog. In the US, that's also been kind of a very mixed bag. Every state has kind of handled it differently. But if you also look at some of the federal courts, like immigration courts, some of which for certain types of proceedings are still able to go forward, and others have adopted more of a electronic and virtual way to move forward. So I think that the key is that we've got a lot of tools and solutions, and now it's really up to the users to demand it. And it's really in the benefit, I think, of long-term to adopt it and to fully make it part and parcel of the choices. For arbitration, it's always been about choice, right? That's, again, one of the other hallmarks of arbitration. Parties have a lot of autonomy in making those decisions. So going to, William's point about documents only arbitration, I think that's also really very much party driven, and it lends itself very well to certain types of cases, especially smaller cases or less complicated cases. So I think that's also another tool in the toolbox that can be used to make and that it remains relevant, that arbitration and our traditional courts remain relevant.
Thank you so much. I don't know if also Stefano wants to comment. Yeah, sure, please.
Okay, well, I think I see there should be also some, let's say, coverage by our legislators. I don't know whether you are aware of the recent Supreme Court decision in Austria, in Vienna, because one of the open issues is whether parties have the right to be heard physically and not only remotely. My answer is they have the fundamental right to be heard, period. Whether in person or by Zoom, that does not make much difference to my right, provided that it's equal to the other party's right. So I don't see a real public order principle violation to organize a Zoom conference with the parties. But our laws should follow. Either our laws, or if it takes too long, our jurisprudence, as it has been done in Vienna, in Austria, first of all. So this is something. And then I see another open issue that should be fixed, that is how the award should be signed. Because according to the New York Convention today, apparently, let's say apparently, or generally speaking, you need a hard copy signed by the arbitrators if you wish to enforce the arbitrator award around the world according to the New York Convention. But so we are back to square zero. You need an hard copy. You need to go to the post office or you call DHL, you need to sign physically and send it. Why? For example, in Italy, lawyers and many other professionals, we have what we call digital signature that has exactly the same effect of my pen signature. So, but the New York Convention leaves open this issue. Again, I have my own answer, but I think that that's something that should be some way solved once forever or governed. So I say, I believe that the remote hearings should find, let's say, legitimacy also by law / and or by jurisprudence, and a digital signature of the final award should also be find the legitimacy. I would say, according to the New York Convention, although there is no way to reopen the text of the New York Convention today, and that would be a very, very crazy move. But we have to find somewhere to adapt also our legislations to the new normal.
Thank you for sharing this. Actually, we talk about an hybrid future. So are we ready? Would be my question for this hybrid future. I don't know if Ahmed, William, Bashar want to comment on this or give us any other topic at the end.
Thank you, Alessio, for this call. I think, yes, I mean, determining if countries are ready or not ready, it's something that it's quite, I would say, bizarre, because in some countries, first of all, there should be a will for change, and then they have to be like put in place some strategies for change, and then resources to make this change happen. So thanks to Ghada, when she mentioned the experience of the United Arab Emirates, when 10 years ago they moved, even with the slow internet connection, to make available legal information, and cases are available online, and people can access these cases and access I mean, at least the legal information, the laws, etc. So that contributed a lot to, or paved the way a lot for more digital justice system and access to justice digitally. I mean, and that came by the will, for first of all, and then some strategies were put in place, and then resources to implement those strategies. Likewise, we see now many countries moving towards the digitalization of their courts. For example, Egypt is moving towards the e-justice system and digitalization of the courts. The government, alongside other donors, puts many resources to reform the courts, to make everything available digitally, to make laws available digitally, to make charges available digitally, to make court decisions available digitally, as well as paying the fees by digital means. So that, of course, make I mean, waiting time, crowded courts, I mean, full of people during crisis, or even after crisis, beyond the crisis, where people in remote areas, they can't access courts or can't move to attend the court sessions, at least. These are all there, and I mean, they aren't any more dreams for us. They are just number of actions need to be taken and need to be put in place, and will behind all of that to make them realized and reality.
Thank you so much. I don't know if William and Bashar want to add something on this to wrap up at the end, or if you have any other comments you want to give. There are no questions from the audience to this point. It means that you all have been so clear and you raised so interesting topics that our virtual audience actually can check and share, because we share a lot, I think, today.
If I can jump into the discussion, I think over the years, the WTO, I would say that it's a traditional institution that's still evolving compared with the other arbitral institutions. So it would be interesting to see how, what the WTO can learn from these arbitration institutions in terms of using the technology. I mean, it's obvious that Geneva is one of the most expensive cities in the world. That's why so many developing countries do not have full-fledged WTO missions that cover the WTO matters, and it's quite expensive, where you have to fly in lawyers going there to represent governments, or where you have panelists, ad hoc panelists, fly in there and stay for extended period of time to resolve these type of cases. So I think the WTO has a long way to learn from other arbitration institutions how to use technology, and such save times and money for all those involved in the litigation process.
Thank you so much, Bashar. William, just to close, if you want to give us a final comment.
Nothing really to add. I think it's all been covered, but I think the changes that we've seen over this past year are here to stay. And again, just re-emphasizing what Bashar and Stefano said about the costs. I mean, our clients or the litigants are getting spoiled, I am sure now, by the fact that, well, we can do this online. The litigants, well, they could be at home in their pajamas. Likewise, the lawyers at home in their pajamas, without having to get on a plane to travel to Geneva or Milano or Taipei or whatever. And again, like I said, the costs, never mind that, but the cost of, you know, the lawyers and the arbitrators starts the minute they walk out the door. So, hey, if I'm being paid by the hour and I've got a 4-hour hearing, 8-hour hearing, that's all, you know, the litigants are paying for, rather than 2 days of traveling to Geneva, 2 days of traveling back, you know, getting settled there over a weekend or whatever. I mean, the costs are going to be in thousands of dollars. And I think this is, and the good thing for this is going to save and reduce the costs of arbitration. You know, I've been doing a lot of arbitration training over the years, and we talk about, oh, the speed and efficiency and the cost effectiveness of arbitration. Well, again, the minute you send someone on a plane to Geneva, anyway, that's all I have to say. Thank you so much for everyone for listening.
Thank you so much. I think it's a perfect closing that's in a way sum up what I've been saying also concerning the environment. And I thank you all of you for your interventions. So all our speakers, the audience for having been connected and so through technology, just to quote a topic that has been crucial in arbitration in 2020 and in the future. And I thank also my colleagues that assist me in the moderation of this webinar in the remote room. And I hope to see you soon for another of our events. And thank you, and have a good evening.